Thank you for your content. You're welcome. I have property in Florida. Is a quitclaim deed the same as a ladybird deed? No. These are two different types of deeds. So what a quitclaim deed does is it transfers interest in the property immediately. So if a parent, for example, decides they're going to do a quitclaim deed to put their kid on the title of their property, either to give the property to their child or to add the property, add their child on the title, this is an immediate transfer. It takes place right away, meaning whoever you add to the deed has an immediate ownership in the property, which has a couple of different consequences. One, if you're thinking that you may need Medicaid at some point in the future for long-term care, a quitclaim deed is often not a good idea because it is viewed as a gift, and Medicaid has strict penalties for gifts if they're made within 60 months, 5 years of you needing Medicaid. This is called the Medicaid look-back period. So it's often not a smart estate planning method to add your child to a deed using a quitclaim deed, or to give property to your child using a quitclaim deed in order to make sure that it avoids the court process called probate and go to your child directly. This isn't a very smart planning method because it could affect Medicaid benefits. The other thing that it can do is, depending on what your child's going to do with the property, and especially if you're just adding your child or someone else to the title, if they later on down the line end up selling the property, they're most likely going to need to pay capital gains tax. I mean, I don't know the specific scenario, but capital gains tax could come into play in that scenario. And probably the biggest issue of all is that you're giving up ownership rights. And along with giving up ownership rights, you're going to be potentially giving up your current homestead exemption. Property taxes could go up. If you just add someone to a deed, if they have some type of liabilities or they get in some kind of trouble down the line, your house could potentially be put at risk. So there's just many reasons that this often, under most circumstances, is not going to be a preferred method, especially if you're looking at it for an estate planning method. Now, a ladybird deed, on the other hand, is not considered an immediate transfer of a property right. So what a ladybird deed does, much like a bank account that's payable on death or transferable on death, the beneficiary, or the person who's eventually going to be getting the property, doesn't get a current ownership interest in the property. They have the chance of getting an ownership interest in the future. And why I say that is because with a ladybird deed, the person who owns the property is remaining the owner of the property for the time being. They still have all rights to sell the property if they want, reverse mortgage, rent it, they can do whatever they want. And the beneficiary, who's called the remainderman on the ladybird deed, can't prevent them from doing anything because they don't have a present interest in the property. And because they don't have that present interest in the property, this also is not considered a gift for Medicaid purposes. So it doesn't mess with the 5 years if you're thinking that Medicaid might be something that's going to be potentially needed within a 5-year time frame. You don't have to worry about gift rules with Medicaid for a ladybird deed. The other thing that's really nice about a ladybird deed is if you do keep the property and whoever you list as the beneficiary inherits the property upon your passing, if they're going to turn around and sell the property, as long as they're selling it within about 6 months to a year, we're probably not going to see any capital gains tax, because they get to calculate taxes based on what the fair market value of the property was on the owner's death versus what they sell it for, rather than what the owner bought it for versus what they sell it for. So that's often a very big difference, and it means that there's also not going to be capital gains tax. So for that reason, that's why the ladybird deed is pretty much always going to be preferred in an estate planning setting, or if that's your purpose. Now, obviously, there could be a different purpose, which is why it's really important to talk to a qualified attorney to decide what is going to be right for you. But the main purpose of this video is to state that no, quitclaim deeds and ladybird deeds are not at all the same thing. They're very different. They're going to be used in different scenarios. So it's important to talk to a licensed professional before you just go and try to do one of these deeds on your own, which I would never recommend. So I hope this answers your question. And if you have any other questions about ladybird deeds, estate planning, asset protection, elder law, probate, and you're in Florida, please don't hesitate to contact our office at Cause Law Office. We're the non-stuffy attorneys, and the link is in my bio.